Well, good afternoon, educators and administrators. My name is Michael Brown. I'm the Legislative Affairs Director for the Indiana Department of Education. Thanks for joining. This is a Legislative Affairs outcome presentation that I am presenting to all of you as a result from the 2020 legislative session that wrapped up in March this year. And we felt that this would be beneficial to you all on top of the guidance documents that we have provided through Dr. McCormick's weekly updates, in addition to the Legislative Affairs website that we have posted as a compilation of all of those guidance documents. So wanted to take just a little bit of your time here and quickly go through some items, some bills of importance for, we believe schools should and administrators should be aware of at the very least. And just kind of talk you through a couple of bills that happened this past session. So without further ado, we'll go ahead and get started. First slide up is just letting you know where to find complete guidance for each enrolled act that we have issued guidance on. That's there at that link. It's a clickable link. It's a Legislative Affairs website. I have to note, and I might say this a couple times throughout the presentation, that this presentation is not to be used as official guidance. Please go to this website and click on the documents that pertain to that particular bill or legislative act that you would like to look at as official guidance. It's going to get more into the weeds, whereas my presentation is really just going to get, maybe at times getting a little bit of weeds, but be overall pretty high level. So please, once again, take a look at that website if you have any questions about guidance. And at the end of each guidance piece, there is contact information for the specific person at the department who can best direct your question if it's not answered in the guidance piece. The second slide here are the final education bill counts. On the far left-hand side, we started with 166 total education bills introduced in the General Assembly. That would be both from the House and the Senate. If you look over at the top right-hand side of the screen there at finish, we had 27 total bills go to the governor for Governor Holcomb's signature. So if you look at the 166 as compared to the 27, that does mean a lot of times that bills that were introduced were blended into another bill or an omnibus bill, if you will. So ultimately, at the end of the day, there are 27 particular pieces or specific pieces of education, K-12 related bills that we dived into and offered guidance on many of them. So there's that screen. And let's go ahead and get started with Senate enrolled acts. A little caveat here in the bottom left, unless otherwise noted in red, the following provisions on all these slides took effect July 1st, 2020. And then UP is my designation that these bills, if noted, are effective upon passage. And at this point, they've all passed and were signed by the governor, so they are all effective if they have the UP designated by that. So first up, we have SEA 2, or Senate Enrolled Act 2. That implements the 2-year hold harmless policy for state accountability grades. Please know that this does not affect federal accountability grades. It's just our state accountability grades. And also specifically, a school corporation may not use iLearn assessment results or state accountability grades for the 2018, 2019, and 2019-2020 annual performance evaluations of certificated employees unless the use of such data would improve the annual performance rating of the certificated employee. In addition, the official A to F letter grades for the 18-19 and 19-20 school years may not be used for purposes of statewide consequences or interventions. So if you're in consequences or interventions, please see that guidance document. Maggie, our Director of Accountability, spelled out in pretty good detail the provisions of this particular bill, and she did a really great job of distilling it and making it digestible if you have any questions. So once again, please, as always, I direct you to the website to take a look at this particular piece of guidance for Senate Enrolled Act 2. Senate Enrolled Act 190, really is its aim here is for school business officials. Certain road and bridge projects are not considered controlled projects, and therefore no referendum would be necessary. Really just want to make you aware of this bill. I know Denny Costerison has made his folks aware of Senate Enrolled Act 90. So just take a look at the slide. If you have any questions, feel free to reach out to us or your school business official. I'm sure they are well aware of this bill, but I just wanted to put it up here on the screen for your knowledge. So Senate Enrolled Act 246 requires an MOU, a Memorandum of Understanding, to be in place with a community mental health center or a provider certified or licensed by the state to provide mental or behavioral health services to students. There's two different points for which an MOU must be established, and let me go through these. So number one, by July 1st of this year, so back in July, each school corporation and charter should have entered into an MOU with a community mental health center or, as I mentioned, the provider certified or licensed by the state to provide mental health or behavioral health services to students. If you're a corporation that does not currently have an MOU established, with a provider or a CMHC, the Community Mental Health Center, then you need to work on it now. This should have been in place before July 1st. This memo went out back in May. So our hope is most, if not all of you, have this established relationship. And then, so that's one piece. Then the other piece is looking forward to July 1st of 2021, a bit different in terms of receiving money from the Indiana Secured School Safety Grant. So by July 1st, 2021, each corp, charter, and accredited non-pub must certify to DHS that the entity, the corp, charter, or non-pub, has an MOU in place with a CMHC or a provider certified or licensed by the state to provide the mental health or behavioral services. They must have that in place and certify that to DHS before you can apply for this Indiana Secured Safety Grant. So if you don't have that in place, you're going to get denied from DHS. So on the guidance document that we have listed on the Legislative Affairs website, on the second page of that guidance piece, we have provided a link to a list of providers who are certified and licensed by the Division of Mental Health and Addiction to help steer you in the right direction. So please take a look at that. And if you have any questions, contact information is on there, and we would happy to help you out and assist you further. Moving on to Senate Enrolled Act 295, Child Abuse and Child Sexual Abuse Curricula. So Senate Enrolled Act 295 expands instructional options regarding child abuse and child sexual abuse instruction. This is good because we were hearing from a lot of schools that the law, as it was before this law took place, was that you needed to have evidence-based instruction for students. Well, that's difficult, if not impossible, to find. So the General Assembly and our request came in and basically eased the burden on schools. And now public schools, charters, and accredited non-pubs may use research or evidence-based instruction on child abuse and child sexual abuse. We are in the process of working with school safety specialists, school counselors, school social workers, and school psychologists to help identify effective and promising materials as outlined by the law that schools can utilize for instruction. So once that's completed, we will release that through a website, and that website can be located in the guidance document entitled Senate Enrolled Act 295, number 1 of 2. So once again, if there's any questions, feel free to reach out to me or please visit that guidance document. The other piece to Senate Enrolled Act 295 deals with the Indiana Career Explorer Program, or ICE. This particular portion of 295 requires DWD to implement a new ICE program and to establish the program's requirements. In addition, the legislation expands the teaching of career exploration and preparation models to all students in grades 9 through 12. So, as I mentioned, SCA 295 updates existing statutes, clarifying that the ICE program and standards can be a software-based system that is approved by DWD and not solely an internet-based system. This law also requires DWD to begin the process of procuring an ICE program for implementation in July 2021. Additionally, this law also expands the teaching of career exploration and preparation to students in grades 9 through 12. Previously, career exploration models were required in grades 9 and 10, and career preparation models were required in grades 11 through 12. Moving on to Senate Enrolled Act 319. Senate Enrolled Act 319 made changes to the 2019 requirement for teachers renewing a practitioner or accomplished practitioner license with a PGP and who started their PGP after July 1st, 19 to complete 15 points in the area of career awareness. So now this, what was mandatory as a requirement in 19 is now an option. In addition, they also added some language that asks schools to have more of a career awareness-focused professional development activities that teachers can use for their PGP points. That includes participation in monitoring or coaching students who are involved in and working with students who are involved in or exposing students to real-world competitions or any other types of programs that provide career skills, and including some items that are listed in the guidance document. I will say that Senate Enrolled Act 319 did become effective upon passage, as you see here on your screen. We have updated our licensing homepage to reflect this new information, and so many of you, I'm sure, are well aware of this. And if you have any questions, please feel free to reach out to DOE licensing. Senate Enrolled Act 346 did a couple of things. First, I'll discuss it established a task force to review accommodations, as well as to explore the possibility of separating the academic standard of reading comprehension into a separate reading academic standard and a comprehension academic standard. This legislation also addresses the need for notice to be developed and distributed to parents about accommodations that the student will need to be permitted to use on all or part of the statewide assessment. So at its core of this particular piece, the law requires IDOE, in consultation with the Arc of Indiana and ICASE, to develop a notice for parents and students with disabilities in grades 3 through 5 who have accommodations on their IEP, their service plan, their choice special education plan, or a plan developed under 504, that the student won't be permitted to use these accommodations on all or part of the statewide assessment. That is still, as of this recording, is still being developed, and more information will hit Dr. McCormick's weekly updates as our team and others work on this initiative. IDOE will also make a copy of this notice available to each school by February 1st, 2021, and each school must provide a notice to the parents and discuss to determine whether the student may be eligible to opt out of any applicable section of the statewide assessment. So once again, just wanted to put this on your radar. This is very much work in progress, so we will keep you updated via weekly updates, Dr. McCormick's weekly updates, and through the Legislative Affairs website. Senate Enrolled Act 398. Have a couple pieces of guidance on this particular bill. First, let's talk about patriotic youth membership organizations. So Senate Enrolled Act 398 provides that upon request of certain patriotic youth membership organizations, public schools, including charters, shall provide at least one time a year, a day and a time, which may be during the school day as approved by the school, for the representative of the organization to provide information to students on school property. And the information provided by such organizations includes how the specific organization furthers the educational interests and the civic involvement of students consistent with good citizenship and moral instructions. In addition, the law requires a public school or a charter school to conduct an expanded criminal history check of the representatives of those organizations. So please take a look at the guidance we have issued. The law does stipulate the definition of a patriotic youth membership organization. That is an organization as defined under Title 36 of the U.S. Code. We do have a link in the guidance document so you can see that for yourselves, what organizations may be included. Senate Enrolled Act 409. This bill removed the requirement that a principal of a school must send notices to the BMV to revoke a student's employment certificate and driver's license or even their learner's permit. So in addition, the act renamed the Bureau of Child Labor to the Bureau of Youth Employment. So if you, as a principal, do still want to send that information to the state, number one, you're not required to do so. Number two, you're sending it to the Bureau of Youth Employment and not to the Bureau of Child Labor. In addition, schools are no longer required to provide written exceptions for students less than 18 years of age to work during school hours. This law did become effective April 1st, 2020. So at the end of the day, what does this mean for schools? It means that beginning July 1st of 2021, schools no longer need to issue work permits to minors. Schools are completely out of the work permit game after this date, and it's all handled between the employer and the state. Now moving on to House Enrolled Acts. Same thing here. Unless otherwise noted in red, the following provisions take effect July 1st, 2020. House Enrolled Act 1002. This amends what was existing law by removing the requirement that student assessment results from the statewide standardized assessments be used as part of the certified employee's annual evaluation performance plan. So decoupling. We do have guidance out on this, so please take a look at the website. We have a few pages of guidance for administrators to take a look at, and if they have any questions, we have our evaluation homepage that folks can visit for more information as well. House Enrolled Act 1003. Even though we've issued a couple, actually 3 pieces of guidance here, I'm really going to be touching on 2. This was a various education matters bill and affected numerous parts of the Indiana Code. The first one is the annual financial report. Before, schools needed to publish a full report, publish that or send it off to their newspapers and get that published in the newspaper. Well, language was amended, allowing a school corp to either publish the full report still or publish a summary report that includes a description of how to find and view the full financial report on the internet. School corporations must publish this report no earlier than August 1st and no later than August 15th. The other part of 1003 that I'd like to touch on is the required teacher trainings piece of this legislation that received quite a bit of fanfare this session. So at the end of the day, as it relates to this particular piece, it requires the state board to determine the timing and frequency of certain trainings. In addition, state board must determine whether these trainings can be combined or merged, or even the method of carrying out these trainings. This includes whether the training should be required for purposes of obtaining a license, or renewing a license, or in consultation with teacher prep programs as part of the completion requirements of a teacher preparation program. So as of July 1st of this year, State Board had the authority to provide changes in training requirements for the following training items: bullying, child abuse and neglect, suicide awareness, reporting of human trafficking, concussion awareness and equipment fitting and heat preparedness, and proper technique. In addition, HEA 1003 deletes the CPR requirement for the initial license and renewal, and State Board is now charged with making those CPR requirements. It's important to note, very important to note here, that until State Board releases the guidance and the parameters around this flexibility, schools should continue to administer all required trainings for school employees as they have done so in the past, using the same timelines and methods described in Indiana Code. And if you look at that guidance document that we issued, at the bottom of page 1, there is a link to that, the most recent required trainings for school employees guide. So unless we hear otherwise from State Board, please march forward with that required trainings memo that we have out there. If you have any questions, please feel free to reach out to me, or as noted in the guidance document, Rebecca Estes will be happy to help you. House Enrolled 1009 is a various welfare matters bill. It had a little dabble of K-12 to the extent that any income earned at a temporary job as a census worker is not considered in determining eligibility for a free or reduced lunch program. So just wanted to throw that up there related to K-12, and in case anyone had any questions, since it is census year. It does remind me, please encourage your folks to fill out census if they haven't done so already. And thank you. House Enrolled Act 1065, it made 4 changes to the current school finance structure. So here's another bill I'm sure that your school finance folks are aware of. First, DUAB, or the Distressed Unit Appeals Board, approves all loans and advances made to the Common School Fund when a school corp seeks to establish a school improvement fund. These funds are to strictly be used for renovations, repairs, improvements, or demolition of school buildings or other school property used for educational purposes. Secondly, the governing body of a school corp may distribute money received through a tax levy or a school safety referendum tax levy to a charter school. This does exclude virtual charter schools. Third, it removes the cap on a school corp's career and technical education enrollment grant amount. And finally, the bill amends language regarding residential or TIF housing areas. As you can imagine, there are certainly more details that are described in the guidance documents that I won't dive into here because I'm trying to make this as short as possible. So please see that guidance document for any questions. House Enrolled Act 1066, another various education matters bill that had a lot for the kids. This one kept us busy this past session, that's for sure. So there are 5 guidance pieces that we have issued on this, and I will go through quickly all 5 of them. The first part deals with how school corporations address transfer students if certain conditions are met. So the Indiana Code was amended and effective July 1st, 2020, requiring school corporations to accept a transfer student who does not have legal settlement in the corp if the student, 1, has a parent who is a current employee of the school corporation with an annual salary of at least $8,000, or 2, the parent earns $3,000 due to being included as an employee in the extracurricular portion of the transferee school corporation's current collective bargaining agreement. Additionally, the student's parent or their parents must reside in Indiana, and the transferee school corporation must have the capacity to accept the student. And finally, a student whose parent does not meet the requirements outlined, as I just mentioned in items 1 or 2, and the school corporation has adopted a policy of not accepting out-of-district transfer students, the school corp may not enroll and may not report transfer students for purposes of collecting state tuition support. Guidance piece number 2 of 1066 here deals with student suspensions and discipline records. So effective July 1st, 2020, all school principals or the principal's designee shall ensure that while a student is suspended from school, and this was existing even before the law passed, that they receive notice of any assignments of work that are due. They have their teacher's contact information in the event that the student has questions. What was added this year was to ensure that credit, in the same manner that the student who, if they were not suspended, would receive for any assignments or schoolwork assigned during the period of the student's suspension, that the student completes. Now, regarding school discipline records, this law requires each school to provide, upon request of another school, a copy of a particular student's disciplinary records that are relevant to the safety of students if the particular student currently attends the requesting school and is currently enrolled at the requesting school. Schools should consult with their local legal counsel to determine how to best satisfy the statutory requirement while maintaining compliance with any applicable state and federal privacy laws. The third part of House Enrolled Act 1066 deals with transportation for CTE programs. This bill detailed the circumstances under which a school corporation may use a special purpose bus to and from a CTE education program. The bill requires that when more than 8 or more students are being transported for this purpose, a special purpose bus must be used. The bill also establishes that if transporting fewer than 8 students to and from a CTE program, an appropriate vehicle may be used. This is the same vehicle that you can currently use for transportation of homeless and foster care students. It is recommended that schools and the school districts consult with their local school attorney and insurance company regarding any liability issues that can arise in the use of either a special purpose bus or an appropriate vehicle for transportation of CTE students. In particular, if you are providing to and from home to the CTE program. The fourth piece here, and the last piece that I will go over on 1066, deals with some new reporting requirements that the General Assembly has asked the department to provide them. So in December of 2020, the department is going to issue a report that will provide the public with information about the relationship between ADM funding and course completion. Specifically, the department must prepare a report for school corporations, charters, and choice schools detailing fall and spring ADM, enrollment numbers, the number of students participating in the statewide assessment, and the number of students enrolled in the school that are 20 years age and older. So ideally, the report will show a strong relationship between tuition support and course completion for each school. Course completion data is being measured as an output against the input of state tuition support. Now, there are several actions schools can take to prepare for this publication, so please see the guidance document as those items are listed there. House Enrolled Act 1091 provides that a student meets the residency requirement for enrollment at a public school if the parent is transferred or is a pending transfer to a military installation. A student may enroll at a public school if the parent or a step-parent with whom the student resides, 1, has transferred to or is pending a transfer to a military installation within Indiana while on active duty pursuant to an official military order, and number 2, has submitted certain information, including official documentation, as to be determined by the State Board of Education. Additionally, the parent or step-parent must submit 1, an enrollment application as determined by the school, and 2, documentation as determined by the State Board regarding the transfer or the pending transfer. Next, the parent or step-parent has 10 instructional days after their arrival date to provide proof of residency. This proof of residence documentation has yet to be determined by the State Board. But when it is determined, we will be sure to share that information out through one of the weekly updates. If a parent or step-parent fails to provide this proof of residence within those 10 days, the public school may exclude the student from attendance pending an expulsion proceeding. House Enrolled Act 1182. This bill affected numerous parts of the Indiana Code. As it relates to schools, schools need to replace the methods for prevention of AIDS with HIV within their curriculum. Secondly, schools must comply with the records request made by this newly established Suicide and Overdose Fatality Review Team, or SOFR. In terms of schools replacing their methods of identifying AIDS and replacing with the HIV curriculum, we are in the process of developing instructional materials in partnership with the Indiana State Department of Health. Once those materials are finished, we will publish those on our website, and we'll let you know through one of Dr. McCormick's weekly updates. In terms of the SOFR, the Suicide Overdose Fatality Review Team requests, schools, as the law requires, must comply with the records request made by this team. Schools should develop a standard protocol designed to comply with a SOFR request for records. House Enrolled Act 1225. This act removed the requirement that black reflective tape be affixed to school buses. So back in 2019, the General Assembly passed Senate Enrolled Act 2, which required all school buses to have black reflective tape mounted to the bumpers and the sides of buses. It was determined after that law passed and was signed that this requirement was not needed. And here we have House Enrolled Act 1225 that undid that requirement. So administrators, drivers no longer needed to have, by state standards, this black reflective tape. House Enrolled Act 1265, drinking water testing. This bill requires each school building within a school corp to test their drinking water for lead levels. There are exceptions, though. If available, schools that conduct lead testing can seek any state and federal grant money. This includes grant money under the lead sampling program conducted by the Indiana Finance Authority. I will please note there are special testing requirements for school buildings located in Lake County. So if you are a Lake County school corporation, please, and every school corporation, please take a look at this document. But if you're a Lake County school corporation, please take special notes, which I will explain here in just a moment. So for most districts, the law says that not later than January 1st of 2023, all schools shall test their drinking water to determine if lead levels exceed 15 parts per billion or 15 1,000ths milligrams of lead per liter of water. Exceptions to this testing mandate include those buildings that, one, were tested by the Indiana Finance Authority program in 2017 or 2018, two, were tested in the lead sampling program for school buildings and child care facilities by the Indiana Finance Authority in 2019 or 2020, or three, were otherwise tested for compliance to the above standard at least once since 2016. Now, Lake County, a little bit different here. If you're a school corporation in Lake County, after the 2022 calendar year, every school building located in your county must be tested at least once every 2 years. House Enrolled Act 1283, teacher preparation and curriculum. Just wanted to make this of note for you all and what incoming teachers have to look forward to in their as part of their curriculum when going through their ed prep program. So teacher prep programs must include content that prepares candidates to use evidence-based, trauma-informed classroom instruction and recognition of social, emotional, and behavioral trauma, and two, provide information on certain laws that are outlined in this bill. And you will see the certain laws, what that means down there at the bottom. And the final bill here, House Enrolled Act 1305, that adds a new mobility code for purposes of establishing a high school's cohort and calculating a high school's graduation rate. HEA 1305 provides that in order to be considered mobile due to a sincerely held religious belief, all of the following must occur. Number one, while a student is enrolled in grade 8, the student's parents must submit to the school a statement from the parent affirming that the parent has a sincerely held religious belief against taking photographs and stating that the student will be withdrawing from school upon completion of grade 10 in order to allow the student to complete a career pathway certification or due to the parent's deeply held religious belief. Also, a statement from a member of the clergy of a religious organization of which the student's parent is a member regarding the prohibition of photographs. Members of the religious organization must be submitted to the school. Number two, the student's parent must provide proof to the school that at least one of the student's parents has been issued a photo-exempt driver's license. And number three, the student withdraws from school upon completion of grade 10. So I appreciate your indulgence for the past few minutes as I quickly went through these guidance documents and this PowerPoint slide. Once again, please take a look at the website. I think I've mentioned that quite a few times. Please take a look at the Legislative Affairs website. Look at these guidance documents if you would like more information, and take a look. We are here to be a resource for you, myself and those directors or chiefs listed at the bottom of this particular guidance documents. We want to help you. We will help you. This one of the last pages here, second to the last slide, are a couple of resources. On June 17th of this year, I updated the required trainings memo to basically just point out House Enrolled Act 1003. That's the required teacher trainings bill that changed this year that put a lot on the state board's lap. So I just wanted to call that out in the required trainings memo. And any future updates, you can visit, there's that arrow, you can visit and click that link for any future updates, should that memo need to be updated here in the future. In addition, on the right there, I've included how to contact your legislators. I encourage all of you listening to this, please reach out to your legislator. Let them know, and let them know how you feel, how things are going for you this year. If there's any particular policy point that interests you, let them know. Ask them to sit down with you, have a phone call, email them, establish that relationship. It's vital to the process, because if they don't hear from you, that's the best thing that they can do to arm themselves with the knowledge is to hear from you. And so I encourage you to please reach out to your members of the General Assembly, and that link will tell you who your member is. Here's the last page. If you have any questions, feel free to reach out to me. Once again, Mike Brown, my email is right there. Also, I will let you know in looking, if I had a crystal ball, I would really love it right now. But if there's one last word I would have for you all, and mainly really for administrators, is, and looking forward to our next budget cycle in light of this year and how things are shaping up. Be very conservative with your spending, and be very mindful of that, because we want to be very careful, and we're not, we don't know for sure what's the financial status of the state is going to be next session when a budget is worked out. We're certainly optimistic that things will be okay, but we always got to plan for the worst. But continue doing what you all do best. That's educating your children. From all of us here at the department, we appreciate you very much. We know it's not easy. We know you've put a lot of time and effort and work in developing your plans and making this work this year for students. So thank you very much. Best of luck this school year. And once again, please reach out if there's any questions. Thank you.